So, good evening, everyone. So, welcome back to our current affairs sessions. As KP sir is unavailable today, I'll be taking up some topics with respect to polity and governance. All right. So, most of the students are from our institute itself. I could see some pretty similar familiar faces. So, there is some issue with regarding the pardoning powers of president recently, which came up in news in numerous instances from the last couple of weeks. If you could see, can you tell me any instances in which pardoning powers of president has been the bone of contention in recent news? Perarivalan case, yeah. Apart from that, very recently, even this week back as well, last 7 days back you had it, even earlier times also, continuously every month this has been in news. In what all instances have you come across this pardoning powers of president? Why is this in news? One is Perarivalan. Who is this Perarivalan? Convict in the Rajiv Gandhi assassination case. Apart from that, any other instances? Are you all reading newspapers? Yes? Have you heard the name of Abu Salim? Abu Salim. He is a convict in Mumbai blasts, which happened in the year 1993. Mumbai blasts 1993. When that happened, Abu Salim was the convict. That was in news recently. And on top of that, you have something called as 75 years of independence. What is the tag that the government is propagating? Azadi Ka Amrit Mahotsav. On the occasion of 75 years of independence, the central government is also of the opinion to remit some of the convicts who are in sentence for their life term. So, in all those instances, there is something called as special remission to the convicts who were convicted in the jails on the occasion of 75 years of independence. Under that particular tagline, the central government wants to release some convicts from the jail. So all these issues, whatever the three instances which I have been discussed, all these issues brings into the framework, the pardoning powers of the President of India. So now, which article of the Constitution talks about this pardoning powers of President? Article 72. This is the specific article which talks about the pardoning powers of President. So, like the case of President of India, do governor of a state have pardoning powers? Yes or no? Yes. So, which article talks about the pardoning powers of governor? Article 161. Talks about the pardoning powers of governor. Are the pardoning powers of both president and the governor same? No. In what way are they different? Except death sentence. Martial law. What is martial law? What is martial law? Enforcing all the armed forces, the servicemen who are stationed with the armed services, they have to be tried under the court martial. For all the judicial matters with respect to their acts and deeds should be tried under court martial. That comes under the martial law. So all cases relating to the martial law has to be decided by the President of India only. The governor has no power to decide on the cases with respect to court martial. Apart from that, what are the other differences? Death penalty. So if someone is convicted of death penalty, who has the pardoning power? Only the president. Does the governor have anything to do with decreasing the sentence of death penalty? Yes or no? Like if someone is convicted of death sentence under the state law, let's say whatever the president is imposing, whatever punishment is imposed by the law, that comes under the union list. Then the power of the pardoning rests with the President of India when it comes under the union list. If the acts were done under the state law, if the state law is convicting someone of the death sentence, then what happens? If state law is convicting someone of the death sentence, then who has the sole authority to decide on that death sentence? President of India only has that. I'm talking about the pardoning power. So now talking about the various other powers. Apart from pardoning power, what are the various powers that you have under pardoning? Like decreasing the sentences? What are they? First one is pardoning. Next. Commutation. Next. Respite. Next. Remission. Finally. So, can you tell me the difference between all this? What do you mean by pardoning? Firstly, what is pardoning? What do you mean by pardoning power? Completely convict. Completely freeing the convict from all his punishments. So, it is completely taking away the sentence as well as freeing himself from the conviction, whatever conviction he has done. So, he is set free from all the charges imposed on him. That is what is known as pardoning power. So, the pardoning power for a death convict rests with governor or president? President of India only. The pardoning power rests with President of India only. Whereas, when coming to rest all the provisions like commutation, respite, reprieve and remission, that can be handled by both President and the governor under this respective articles of Article 72 and Article 161, which gives the power to the governor, constitutional power to the governor. So, pardoning power is restricted only to the president, whereas all these powers were given for both president and the governor. So now, pardoning means freeing himself from all the sentences and charges which were imposed on him. What is commutation now? What is commutation? Reducing the time frame. Means, example, time frame or decreasing the punishment. Nature. So, the punishment, which is a rigorous imprisonment, can be substituted with a lighter one. The rigorous imprisonment can be substituted with a lighter, simpler punishment. That is what is known as commutation. So, now the next one is respite. What is respite? Decreasing, changing the character. Character can be changed or not? Time period. So, like, what is the major difference between commutation and respite? Time period change untadi. Ante time period change untadi vani character of the punishment will be the same. Yes. So the major difference is in respite, the rigorous punishment can be changed to a lighter one. The lighter sentence can be improved. Original ga sanction చేసిన punishment ki lighter sentence can be imposed, but there is a special note to some special cases like pregnancy of women or any such disability of any person. If those are the conditions, this respite comes into play. If not, the difference between commutation and respite were almost the same. Reducing the sentence from rigorous one to the lighter one. That remains the same, but only in special situations, special fact. When that is considered, this respite comes into play. Next one, remission. What is remission? Reducing the period of sentence. Time period only comes in this case, whereas not in this case. Only the nature of crime is considered in commission, commutation and respite. Whereas the time period comes into play only in this place of remission. The time period is reduced. Let's say you are imprisoned for 15 years of sentence. That can be reduced to some 5 years of imprisonment. That is what is known as remission. Remission. And finally, last one is reprieve. What is reprieve? What is reprieve? Reprieve. What is reprieve? Repriving. Reducing, or there is a stay which is imposed on the execution of sentence. So for temporary period, your sentence is halted. So there is stay in the execution of sentence for temporary period. That is what is known as reprieve. Reprieve. So what is the necessity for imposing this reprieve or granting this reprieve? What is the need for reprieve? Why this power should be granted for the convict? Why should reprieve be? Because already he is convicted. But why there needs to be a stay on his conviction? Maybe he can go to the president for pardoning. Anything else? Why this reprieve is being kept as one of the pardoning power, and why such stay has to be imposed on the convict? Someone is telling something. To gather evidence. Already evidence is gathered and he is convicted. So there is no point to?
Maybe some new evidence popped up proving that he is not guilty.
Not guilty. So to ensure him a fair trial, in India, which legal system do we follow? Reformative justice system. What do you mean by reformation? Reformative justice system. Reformation ante? To transform an individual, to make him realize that he has done something wrong, and to transform him as an individual and free him to live in a society. That is what is known as reformative justice delivery system. In India, we follow that reformative justice delivery system. For that purpose, to establish that reformation in any particular individual, this reprieve is granted. Even if he is held guilty of it, and convicted for the offense also, after undergoing some 5 years or 10 years of imprisonment, the character and the mindset of that particular individual might change. He might have regretted for whatever acts he have done. Then he has to be given a chance to live as a normal individual. He has to be freed. For that, this reprieve is being brought into the picture. So the stay which is imposed earlier on his acts or deeds can be again considered by the president by utilizing all these pardoning powers. For that reason, this reprieve is being put as one of the pardoning powers of the president, so that he can be provided some fair trial. That is the difference between all these pardoning powers. So now, in various instances, this has been used. So what is the procedure in which this pardoning power is being imposed by the President of India? Under Article 72. What does Article 72 of the Constitution say? What does Article 72 of the Constitution say? 72. ఏం చెప్తుంది? Discretionary powers of President. Does the pardoning power have a discretionary power? Like, is it discretionary on the part of President? Yes or no? No. When you say no, then what is the procedure that is laid down in the Constitution? It is a discretionary. So if the president thinks that some convict has to be pardoned, pardoning means completely dissolving the sentence or the conviction which that person is holding. If he thinks to his mind that he has to be freed completely, can he do so? Yes? Yes. It can be imposed. So, does Council of Ministers come into play when exercising this pardoning powers of President? Do Council of Ministers have any role in the pardoning power of President? Yes or no? Mm-hmm. Yes or no? Yes. So the President has to act on the aid and advice of the Council of Ministers only when pardoning any convict of his sentence or of his convention. It is not the discretionary power of the President of India alone. The Council of Ministers has to advise the President on doing such acts or deeds. So, on the aid of that Council of Ministers only, he can take up that pardoning powers. So, let's say the Council of Ministers has recommended the President of India to dissolve someone, completely take off the charges on some particular individual. Then the President can do so. If the President is not of the opinion or not of the mind that he don't want to do that, but the Council of Ministers has recommended him to do that, then what is the course of action available to the President of India? He has to go ahead with the advice given by the Council of Ministers, or he can withhold that, or he can withhold that recommendation. Can he do that? Can he do that? Article 75. There is something called Article 74, Clause 1 of the Constitution. Article 74, Clause 1 of the Constitution. This particular article says that if the Council of Ministers recommends the President to use his pardoning powers, and if the President thinks that he should not do so, he is of the contrary opinion, the Council of Ministers asked him to completely dissolve, but the President don't want to dissolve the charges imposed on that particular individual. Then under this Article 74, Clause 1 of the Constitution, the President can make them to reconsider the recommendation made by them. So, reconsideration clause is also available. Reconsideration clause is also available to the President, in which he is directing the Council of Ministers to reconsider the recommendations made by them. So now what happens? Again, whatever the recommendations were made by the Council of Ministers were sent back again to them by the President of India. So now what happens? Again, the Council of Ministers sit together, discuss on that, and they can come up with either the same decision or the opposite decision. Only two options are available to Council of Ministers. So what happens if the Council of Ministers has come up with the same decision again? What happens then? The President has to compulsorily follow whatever the decision was made by the Council of Ministers. In this case, there is no other option or no other way out for the President of India to take any other action against the decision of Council of Ministers. So this particular Article 74 Clause 1 makes or gives a clause for reconsideration. It gives a clause for reconsideration, but if the decision is again coming back, the same decision is coming back, the President is under obligation to accept that. That are the main provisions. So can we say that there is a limitation on the pardoning power of President? Is there a limitation on the pardoning power of President here? Yes or no? Yes, there is a limitation on the pardoning power of President. So now what are the various instances? Even the Supreme Court can interfere in the pardoning power decision made by the President or not? Can Supreme Court interfere? Yes or no? Yes. The Supreme Court can interfere, can look into it. Alright? So, when Supreme Court has the power to interfere, so whenever you come across any issue with respect to polity and governance, the major aspects which you need to consider is the constitutional backing, whatever articles are talking about the pardoning powers and all. And the second aspect that you need to look is when Supreme Court has any form of interference in this particular issue, there must be some landmark judgments that it has propagated or it has pronounced with respect to this pardoning powers. Do you have any landmark judgment with respect to the pardoning powers of president which the Supreme Court has pronounced? Maruram versus Union of India. In which year was that? Maruram versus Union of India, 1980. Apart from this, so these has to be incorporated in your answers. Whenever you write any answer with respect to pardoning powers of president and all, this basic constitutional provisions has to be visible, and then the Supreme Court landmark judgment has to be there in your answers. What is the second constitutional Supreme Court judgment that was? What was that? Dhananjay Chatterjee versus State of West Bengal. Which that was in the year? Dhananjay Chatterjee versus State of West Bengal in the year 1994. These are the two major landmark judgments which the Supreme Court has reiterated that the President of India has to act on the aid and advice of the Council of Ministers. In these two instances, the Supreme Court has reiterated that stance that the President of India should act on the aid and advice of the Council of Ministers only. So these are the two landmark judgments with respect to the pardoning powers of the President. So now, what is the procedure? If some convict is held with a death penalty charges, how can he apply for mercy plea, mercy petition? Mercy petition ante? What is mercy petition or mercy plea? Mercy petition is filed before whom? Mercy petition is filed before whom? President of India. So what is the procedure that is followed to file a mercy plea? Will file that. So once it is filed, what is the procedure that it has to undergo? Who is the competent authority who has to look into that? Which ministry? Ministry of Home Affairs. Ministry of Home Affairs is the designated authority who looks into the claims which was made by the convict. And it is the sole authority to accept that, whether the mercy plea is having any substantive basis to be considered by the President of India or not. So the Ministry of Home Affairs is the designated authority. It looks into it and it seeks the Council of Ministers advice. It is laid before the Home Ministry and it seeks the advice of the Council of Ministers. Then it goes to the concerned President. Then his decision is being taken. That is the procedure. So now coming back to the same, like what has happened in Rajiv Gandhi, Pararivalan case and Abu Salim. Recently, last 3-4 days back, there was a news that Abu Salim, who is a convict in the Mumbai blast case of 1993, he has to be freed after 25 years of his imprisonment. 25 years of his imprisonment. Why should he be freed after 25 years? National commitments. with, sorry, promise was made. To whom? To the convict or Portugal? So why does Portugal come into play here? Portugal. Abu Salim ki Portugal ki sambandham enti? And why there is a national commitment made by India to this particular Abu Salim that he will be freed after 25 years? Why is that happening? Have you heard this term, something called fugitive? Fugitive. Vinnara? Who is a fugitive? Vijay Mallya, perfect example. Lalit Modi, Nirav Modi, Vijay Mallya, all these are fugitives. Fugitive ante someone who has fled India, ante for some crime or for some law which is punishing them in this particular country. To avoid those legal consequences, they have changed their residence from India to some other particular country. So who are facing some legal consequences, they flee this country. They are known as fugitives. So this particular individual, Abu Salim, is also a fugitive. He left from India to Portugal. Left from India to Portugal. If he is stationed in Portugal, if the Portugal or the Indians, the intelligence has identified that this Abu Salim is residing in Portugal, can we directly go and arrest him? Yes or no? Yes or no? So what needs to be followed to arrest that criminal who is undergoing legal consequences in our country? What is the procedure? Do you need to take any permission from the respective requesting country? Yes or no? You have to take that. So the person who has fled India and residing in any other particular country, that particular individual is known as fugitive, and the offences which were made by all these fugitives are known as what? Have you heard this term called extradition? Extradition. EXTRADITAON. ఎక్స్ట్రాడిషన్ అంటే ఏంటి? తిరిగి కంట్రీకి అప్పగించడం. సో ఇట్ ఈస్ ద ప్రాసెస్ బై విచ్ ద క్రిమినల్ is being handed over from one country to the other country. You have to request for handing over that particular individual from Portugal to India. That is what is known as the process of extradition. So all the things, all the activities which were related to this extradition has to be governed by certain law or not. Because whatever laws are applicable for the convicts in India, that has to be different from whatever laws were applicable to these fugitives. There has to be some separate laws. So there is something called as Indian Extradition Act of 1962. Indian Extradition Act of 1962. So under this particular act, under this Extradition Act, there is a commitment which was made by both the countries, both the parties involved. One country and the other country under this particular act was obligated to transfer any of the convict who is facing some legal consequences or criminal offences. There has to be interchange or exchange between both the parties under this extradition law of 1962. And this particular law says that after 25 years of imprisonment, that particular convict should be freed from his charges. So this Abu Salim is being prosecuted under this Indian Extradition Act of 1962. So there was a national commitment made by the Indian government that we will be abiding by all the rules which were made under this particular Extradition Act of 1962. So if you give us the convict, we will be sentencing him, and after 25 years he he will be like freed. That is what the treaty says, extradition treaty says. And there are certain specific sections as well. The important section which this extradition treaty, which talks about extradition treaty, is section 2D. Section 2, clause D of this Indian Extradition Act of 1962. It talks about the extradition treaty. So there is a treaty which is being signed or agreed, and it is binding on both the parties or both the countries, that all the provisions in this particular act or this particular treaty as per this section should be followed by both the countries, the requesting country and the requested country, like whoever is giving and whoever is requesting. So both the countries has to abide by this treaty norms. That is what this particular extradition treaty of 1962 conveys. So according to that, he has to be released. That he has to be released within, after serving a term of imprisonment of 25 years. That was the directive which was given by the Supreme Court of India. So now the question here is, the pardoning power and all rests with the President of India, who comes under the executive wing or not. President comes under your executive wing. When executive is involved in the pardoning powers of whoever convicts they are, what is the role of Supreme Court to direct this Abu Salim to release after 25 years of imprisonment? Does Supreme Court have any role to play in this particular case? One? 142. What does Article 142 say? What does Article 142 of the Constitution say? Can? So, in the name of public interest, the judiciary can interfere in any matter which can supersede the executive and legislative arm. That power is granted under Article 142. So, do you think Article 142 of the Constitution is overriding the powers of other two organs like executive and legislature? Yes or no? So, when one organ like judiciary is interfering into the other domains of executive and legislature, what does it lead to? Judicial overreach. So, is judicial overreach in consonance with the separation of powers as mentioned in Article 50 of the Constitution? Judicial overreach, is it in consonance with the separation of powers? Yes or no? What do you mean by separation of powers? Independent? Every respective organ like executive, legislative and judiciary has to work within their respective domains. They should not interfere in various other domains. That is what is known as separation of powers. So when judiciary, by exercising this Article 142 of the Constitution, is it not interfering into the other organs or not venturing into the other organs? India mostly follows checks and balances. Checks and balances. So what is this checks and balances? What do you mean by checks and balances? India is not strict. It can. So when it can and when it cannot, is there any thin balancing or thin demarcation of its venturing? Is there any demarcation like it has to stick only to this limits? So what is the difference between judicial activism and judicial overreach? What is activism and what is overreach? What is the difference, major difference? Vinnara activism ante enti? Activism. Activism means actively interfering or venturing into the functions of other organ like executive or judicial, like legislature. So if there is excess of judicial activism, that leads to judicial overreach. Yes or no? So is judicial overreach good or not? How do you substantiate this point? How do you substantiate the point of judicial overreach? If there is, substantiate the difference between judicial activism and judicial overreach. If that is the question given to you in mains. Can you list out some examples where the Supreme Court has imposed this judicial activism? Basic structure of the Constitution, judicial activism. Yes. Anything else? Basic real-time examples which we frequently see in news. Judicial activism. Judicial activism impose చేసి సుప్రీం కోర్ట్ ఏమైనా జడ్జ్మెంట్స్ తీసుకుందా? Three capitals of AP. Is it taken by the Supreme Court? High courts. That doesn't stand as a judicial activism. Any other examples? Highway. Ban of alcohol on highways. Ban of alcohol on highways. Highway lo alcohol ammocha? National highways lo alcohol within certain radius. 500 meters it should not be. Vedanta case. What does the Supreme Court said in Vedanta case? Assam? Orissa? So basic, that's also right. The basic examples are banning of alcohol on national highways. That has to be the domain of executive. Executive has to take a call. It is not the judiciary who has to impose that. Same is the case with playing of national anthem in movie theatres. Pollution in Delhi. All those. Does Supreme Court has to interfere in those matters and take a call on that everyone should stand for the national anthem before every movie is being played in a theatre. Is it not overreach? Is it not overreach? Is it activism or overreach? How do you differentiate between activism and overreach? Other organs. Yes, that's the perfect example. Like, if it is an overreach, the Supreme Court is directly venturing into the domains of the executive and legislature. If it is an overreach. If it is an activism, it is doing its own functions, which comes under its own jurisdiction. Whereas in overreach, it is directly overriding the powers of the executive and the legislature. That is the major difference. So in this case of Abu Salim, does the Supreme Court confining itself to this overreach or activism? In Perari-Vallon case, Rajiv Gandhi's assassination case, it is directly overreaching. Whereas in this case, it comes under activism or overreach? Activism or overreach? Overreach. See, this Abu Salim has filed a counter petition in the Supreme Court that after my 25 years of imprisonment, I have to be freed as per the Indian Extradition Act of 1964 and the national commitments made by India to the Portugal, I have to be freed. That is the petition which was filed by him. When he filed that, the Supreme Court has interfered and said that he has to be freed. So, after the date of 25 years, I mean from the date of detention, from the day I was held convicted, from that date to 25 years from then, once that date is done, within 1 month, within 1 month of that particular date is finished, the central government has to pass the papers with respect to his pardoning power to the President of India. That is what the Supreme Court has directed. So in this case, it is not a judicial overreach. It is just within the legislative domain of the judiciary. It comes under judicial activism only. It is within the domain of judiciary itself. So the Supreme Court has directed the central government to look into the papers of this particular Abu Salim and release him after 25 years of conviction. That is what is the main crux of this particular issue. So here the key points that you need to notice. What are the key points that you can note from this? Pardoning powers of president. Pardoning powers of president. So what are the key major differences between the pardoning powers of president and governor? What are they? Court martial. If military court is involved, who is the competent authority? President of India. If it is a death sentence, then also president. So these are the major differences and major things that you need to note down. So now, as I have mentioned, the Supreme Court, the Ministry of Home Affairs is the competent authority to issue the pardoning process, So recently, the Ministry of Home Affairs has released some guidelines to release some convicts in the name of special remission process on the eve of this 75 years of independence under the tag name of Azad Ka Amrit Mahotsav. 75 years of independence. This August 15th, when this is going to come, it is going to commemorate the 75 years of independence. And on that particular day, some convicts need to be released by utilizing which pardoning power? Remission. Under remission. So who are all the convicts that can be released on this 75 years of independence? What are the specific guidelines which were given forth or put forth by the Ministry of Home Affairs? Who are the convicts who can be released? Like all the convicts can be released, or is there any guidelines issued by the Home Ministry? It has issued some guidelines. Some are given exemption and they can be released, and some are not released. So the guidelines for which the prisoners who are qualified for premature release under this 75 years of independence are women and transgender convicts. They can be released. Who are aged 50 and above years, they can be released. So these are the special prisoners who can be released under this particular special remission process. First is women and transgender convicts above the age of 50. They can be released. And second one is the male convicts above the age of 60 years and who have already completed 50% of their conviction. They can also be released. The male convicts above the age of 60 years and who have already undergone 50% of their conviction. They can also be released. And also physically challenged and disabled convicts with 70% disability, they can also be released. PH, physically disabled candidates can be released with 70% disability. And terminally mentally ill convicts, they can also be released. And all the convicted prisoners who have finished 2/3 of their conviction can also be released. All the convicts for various offences. For various offences means there is some limitations. Only those convicts who are charged under some certain sections of law only will be released. If someone is convicted of terrorist act, for some terrorist activity, if someone is committed, can he be released? No. There are some limitations again. So for normal convictions, who is convicted, if 2/3 of his conviction is already finished, he can also be released. And also persons who are committed of the offense, who are under the age of 18 to 21 years and who have already completed 50% of the sentence can also be released. The minors, the 18 to 21 age bracket individuals can also be released who have already undergone 50% of their conviction. So these are the various prisoners who qualify for the premature release under this special grant remission process on the eve of this 75 years of independence. And now who are not eligible? Who are not eligible? A person who is convicted of death sentence, he is not eligible. And a person who is convicted of life imprisonment, he is not eligible. And also the convicts who are involved or charged under the Terrorist Activities Act, they are also not eligible. These are the three scenarios which the convicts were not eligible under this particular special grant remission process. Under the TADA Act, Explosives Act, National Security Act, Official Secrets Act, all the convicts who are prosecuted under these particular acts were not eligible to be released under this special grant remission scheme. So these are the key points with respect to all the things regarding the pardoning powers of President and the Governor. All right? Doesn't come under? Actually, if he stayed in India and convicted in India itself, he comes under this Terrorist Act. But he already escaped or fled to some other country. If a person is fled to some other country, he becomes a fugitive. When he becomes a fugitive, those laws will be applicable on that particular person. Pardoning powers. The constitution of itself has mentioned the pardoning powers were given to President and the Governor itself. There is no mention for pardoning powers of Supreme Court. Reason, the constitutional makers has, see, when do you approach, when do you go to the pardoning power? Once all your judicial tries have been exhausted. You can try various judicial processes. Various, like if you are convicted of life imprisonment or death sentence under a subordinate court. If the district court has imposed life imprisonment for you, then what is the way out that you have? You can go to High Court. High Court has imposed death penalty for you. Then what can you do? You can approach Supreme Court. Supreme Court has also again imposed death penalty for you. Then you can claim for the Constitutional Bench. The Constitutional Bench has again imposed death penalty for you. You are left out with no other judicial remedies which were available in the country. All your judicial review or judicial redressal mechanisms were exhausted. Then ultimately, finally, you are left out with pardoning powers, which is vested with the highest power in our country is the President of India. So he has that option. If you have undergone all the conviction process, if you have finished your sentence for more than 20, 25, some have been convicted for more than 40 years also, if they are alive. After that also, it is not viable on the part of the legal system to hang him. Then there has to be some remedy available. If that person has changed as an individual, they can file a mercy plea. That is the last resort available by the President. Yeah. How can you make it justiciable? Like, Okay. ఎవరికి దొరికింది? So, ultimate decision making power rests with who? Like, if you are thinking from the humanitarian grounds, that is exploiting someone or depriving someone One is getting justice and the other one is deprived of it. But if you look from the context of constitutional mandate, or the president or the council of ministers, if they feel that this guy has to be provided this conviction, if they go ahead with it, there is no point in questioning that their judgment, if they go ahead. But if they are depriving someone of that, obviously that comes under a humanitarian grounds. Like, you cannot, like, no one has a point in questioning that, because they are constitutionally abiding by whatever processes is mentioned in the constitution. Live. Once the decision is made, no one can. All right. See you in tomorrow's class.